Alright, so this is the second video lecture on Chapter 2, and this one focuses just on the parts of a trial. So the first one focuses more on what's a trial like, the different entities, and how they get there. Also their obligations. But this one's just going to be the pieces of a trial. The first part of a trial, trials begin with opening statements. The charges are read to the jury, and the prosecutor delivers their opening statement. This is a summary of how the prosecution expects the evidence to establish the defendant's guilt beyond a reasonable doubt. It's often told in the form of a story or a narrative, but the story kind of leaves the jurors with the promise that there's going to be evidence and proof that comes throughout the course of the trial. Then the prosecutor delivers their case in chief. This is the main evidence of, it can be either the prosecution or the defense, but the prosecutor always goes first because they have the burden of proof. The prosecutor is going to present their witnesses and exhibits. They're going to call the witnesses to the stand and engage in the direct examination of these witnesses, and then the defense attorney can cross-examine these witnesses. The prosecutor is going to call maybe a law enforcement officer. What's your name? How long have you been an officer? What are your training qualifications? Were you working the night in question? Okay, and then we're going to lay out the facts piece by piece of what happened. And that process will be repeated for every witness or exhibit that the prosecutor introduces. After the prosecutor concludes its case, the defendant will present its case in chief. So maybe the defendant has an alibi, or maybe the defendant is pleading self-defense or insanity. And the prosecutor will then cross-examine all the defendant's witnesses. After each side rests their case, the trial will conclude with closing arguments by both sides and the judge's jury instructions, and then the jury will deliberate. Now, after the prosecutor gives their open, the defendant can give their open then. In some places, the defendant can hold their open until they start their case in chief. So it's not always the exact same. For closing arguments, the defense usually goes first. The prosecutor will split. So it'll go prosecutor, defense, prosecutor. The prosecutor always gets to have the final say with the jury because they have the burden of proof. So they start and they get to end because they're the one that have the obligation to prove each element of the crime. Throughout this process, all felony trials and most criminal trials today, misdemeanors included, recordings are made. These are done mechanically using audio-video equipment. Some courts still do have court reporters in the courtroom. Because of this, all communication must be audible, and only one person can speak at a time. So court reporters cannot witnesses cannot shake their heads as an answer, as a yes or a no. Everything has to be spoken, and only one person can speak at a time. Because the prosecutor has to overcome the defendant's presumption of innocence and corpus delicti, the prosecution has to fulfill certain requirements during the case in chief, or the court will enter a judgment against the defendant. So they will say, prosecutor, you did not meet your burden of proof here, therefore I'm forced to enter a verdict on behalf of the defendant. So the amount of proof the prosecutor has to present during that trial is called a prima facie case. Okay. So the witnesses that are called during trials, they need to understand what it means to tell the truth so that they can undergo the oath or the affirmation that they're going to tell the truth. And they need to possess some personal knowledge of a perceived relevant fact, remember that fact, and communicate it. So if they saw what happened, if they heard what happened, they have to be able to know what the truth is and remember the event, and then be able to communicate that event. Um, everything else goes against what we call weighting a witness's testimony, not their ability to actually take the stand. So some witnesses you might not find very credible. So for instance, if the defendant presents an alibi and the only person that they can present to be their alibi is maybe their mom, well, she can still testify that she was with her child that day, that time, that place. They were at a movie, they were at this or that, they were at home. But you may not find that as credible as if it was also corroborated by the ticket seller at the movie theater they were at, or by the neighbor across the street who's not going to have any reason or any investment in the case, right? But the mom can still testify. It's just, it may not be as credible as another witness's testimony. The sequence of witnesses just depends on the case involved and the narrative that you're trying to tell as the attorney, the story you're trying to give. But there is flexibility. You can tell things in a chronological, time by time, or you can tell things another way. It just depends on what you're trying to convey. So this direct examination, you might want to come back to this slides as you're working on the podcast assignment later in the semester. This is the questioning of a witness who's on your side. So if you choose the Detective Trap podcast, you're going to presume you're the prosecutor, and you're going to engage her by asking about her name, her address, her occupation, and these just kind of preliminary questions. You need to set the stage about who your witness is. Even if most people know her, the jurors don't, and we have to make our record. The attorney usually, direct examination cannot have a leading question where the answer is suggested in the question itself. The defendant had a gun in his hand, didn't he? Well, the suggested answer in that question is yes. And so on direct examination, we do not ask those kinds of questions. A more appropriate phrasing might be, did you observe a gun? Okay, so maybe this person says yes. Where did you see the gun? Did you handle the gun? Those types of questions are open-ended for the witness to tell the knowledge that they have about the case. During the questioning of any witness, the opposing attorney can say objection. Objections are often based on leading or hearsay or speculation, and the judge will make a ruling on objection as soon as the attorney says, objection, Your Honor, hearsay. Okay. After the direct examination is complete, the other side can ask a cross-examination. This is considered inherent in the American trial system to get to truth and justice. You hope to shake the story or make it look like the witness is not certain. You may also want to show that this witness has some prejudice or bias, or that at some point maybe they did tell the story differently, and so you want to highlight that maybe this witness is not very trustworthy because 2 months ago during your deposition they told their story very differently. So what's the truth, 2 months ago or what you heard today? So you just want to make it look like this witness should not be as believable, because you ideally, this is kind of an adversarial environment where each side is trying to win. After a direct examination, the person who called the witness can engage in a redirect, but this is limited to clarify information during the cross-examination. So you can't just bring up a whole new area. You have to stick to what was covered in the cross-examination. If someone redirects, the other side can choose to recross examine. But again, it's limited to the redirect. You cannot just start a whole new tangent of questions. After this, we're going to have our close of the case. The prosecutor will announce that they've rested their case after all the evidence that they want is in. This is an important point in the trial, because if they didn't meet the prima facie case, the judge is going to decide the case in favor of the defendant. The defense can then present their case in chief at this point. They can present any witnesses they want, any exhibits or information they want. This can be alibi, character evidence, a justification, or an excuse if you think back to criminal law, so self-defense, insanity, consent, any of those types of defenses that were covered. And then after they present, and the defendant may or may not take the stand in their own defense. That's a really complicated issue. After the defendant's case is closed, the prosecutor does have the right to present additional evidence or additional witnesses and evidence, but only to overcome the defendant's case. So they might present something to say, well, you claimed the defendant, all these witnesses said the defendant's a good person. Well, here's somebody who's talking about the defendant's poor character. Maybe they did this thing at work, like they embezzled or something. Okay. If that happens, the defense can rebut and introduce new evidence again, and then we get to the closing arguments. Unlike the opening statement, this is your chance to summarize the case and try and persuade. This is overt persuasion. You should side for the prosecutor because I met my burden and all these things. You should side for the defense because the witnesses were not trustworthy, because my client has an alibi, all these different reasons. And so you're allowed to appeal to the jury based on the actual evidence and all the inferences you can rationally reasonably draw from the presented evidence. At this point, the judge will issue instructions to the jury. Occasionally this does happen before the closing, and like a handful of places it happens after the opening arguments, but usually it's after the close, so that it's kind of the last thing the jury hears before they deliberate. The instructions cover both substantive and procedural law. So the substantive law is like the murder case, and the procedural issues are the burden of proof and things like that. The jury then gets to deliberate. If they cannot agree, it's what we call a hung jury, and this will result in a retrial with a new jury. Or they can decide not guilty. At that point, the defendant would be free to go. And if it's verdict, a sentencing date and time would be set. And oftentimes there's going to be sentencing guidelines and things in place to help figure out the exact sentence for this defendant. So this is the video kind of working through the trial process step by step. If you have any thoughts or questions, feel free to reach out.